teacher, whether they can name any of their children's friends. We have the ability to collect evidence. Okay? Then we go to family court, and it's a free-for-all, and nobody's presenting evidence, and who gets heard is whoever speaks the loudest, and whoever's the most intimidating, or whoever has the best attorney. Now, what we all know is that most family court cases where there's child custody, the people work it out. 80 or 90% of cases get worked out without a lot of contention. It's those 10 or 15% of the cases that take up most of the court's time. And what are those cases? Allegations of child sexual abuse and or domestic violence. Okay, those are the ones that take up all the time. Those are the ones that have a case file that's this thick after several years. Those are the ones the judges hate because they look at that file and their immediate assumption is everybody working on this case is an idiot or a jerk. Everybody on this case, because this case is this thick, that means everybody here has less value than somebody who comes in with a thin file, and that everybody involved in this case is lying and just doing this in order to take up the court's time. And I've heard them say that. I've heard them say, have you looked at the thickness or the size of your file? You guys have been at this for how many years? Well, duh. We have been at it for however many years because the problem keeps perpetuating itself. And the longer a case goes on, the worse it gets for the child. Okay, so what happens to the belief system in the family courts? They start out with the belief that people in family court are going to be contentious and therefore they're going to lie. Okay, now do people in family court lie? Yes, they do sometimes. Do people in criminal court lie? Yes, they do sometimes. Okay, but evidence. Collect evidence. Okay, Richard Ducote, who's an attorney who used to be down in Louisiana, I think he's in Pittsburgh now. Funny guy, if you ever get a chance to hear him speak, very knowledgeable guy, entertaining. He harps on, go into family court with the evidence. Okay, the problem is, even if you collect the evidence and you have it, you've got to get someone to listen to it. And that's part of the problem, is they don't listen to the evidence in family court. If you went into criminal court, think about this. You go into criminal court and you've got somebody who's been accused of child sexual abuse. You go into criminal court and the people walk in, the person who's the victim walks in, can't afford an attorney, but there's a DA there if you're in criminal court, okay? The perpetrator, the alleged perpetrator, has an attorney. And if this was like family court, everybody would just go, well, wait a minute. We think she's lying. Look at this guy. He's a good guy. He's a family guy. He's been a teacher for how many years? We can, get 100 people to come in here and say what a good teacher this person is. Just look at him. He's a great guy. And look at her. What credibility does she have? She's a mom. There's a kid over there who's, this happened when the kid was 5. Are we gonna believe a kid who was 5 years old over this person who's an upstanding member of the community? Okay. So, Judge, we think you ought to just, drop this case and hold the person who made these charges in contempt of court. Okay, if we did that in criminal court, everybody would go, wait a minute. What about calling witnesses? What about people, swearing in? What about presenting evidence? What about the exams that were done? What about? In criminal court, there's a procedure where all this evidence is presented. In family court, you're lucky if they'll let you call a witness, let alone present evidence. So that's where things start to fall apart, is at the very beginning there's a belief that someone's lying because it's family court. Because it's family court, people must be lying. So if we start with that assumption, then everything goes wrong after that. Okay, so a child's not even allowed to testify in family court, except we just got that law changed so that, and Connie just left, but she would know the number of laws. Somebody in here probably knows the number of it. So that if a child is 14 years old and wants to testify in family court, the courts are supposed to allow it now. And it even says the way it's worded, if a child is younger than 14, they should take it into consideration to take what the child wants into view. Now, part of the problem we have is if the child's been taken away and put with the other person, then, sometimes now they've been influenced or whatever. But if we were in criminal court, we'd ask those questions with an open mind. We'd look at those things with an open mind. In family court, there seems to be no open mind. It seems like there's already this train of thought. When we're therapists and we're learning about making diagnoses, they talk about a decision tree. They do this in business too, where you start out where you don't know, you assume you don't know what's going on, and you look for evidence that'll take you in one direction, and if it takes you in that direction, then you look at the next direction it's going to take you, and you follow that trail. It's pretty much what you do in a criminal court case. In family court, there's no decision tree like that because it starts with the assumption that because it's family court, these things are probably not true. Now, if you try to present evidence in family court, or if you try to cite research in family court, you're pretty much ignored, and most of the time there's no court reporter. So imagine in criminal court if there was no court reporter. Okay, and somebody is convicted or not convicted, how would you ever appeal a case if there's no record of the case? How would you appeal the proceedings of the case or decisions made by the judge or statements that were made by witnesses that seemed inadmissible if there was no record of your case? Now, some counties do have court reporters, but in Sacramento County, there are no court reporters. At the end of it, the judge either scribbles, handwrites something on the order, or they assign one of the attorneys to write a summary of what happened, prepare it, then the other attorney approves it, and then they submit that to the court. But there's no court reporter unless you pay for it. Do you know how much that costs? Okay? So there's no record of it. So how do you appeal a case that has no record? All you can appeal is the decision. Okay, now in criminal court, judges are forced to follow certain procedures because of appellate law. And what that means is, for those of you who don't do a lot of work with the legal system, what that means is the cases have been appealed, the appellate courts have made a decision about something, and once an appellate court makes a decision, then that becomes law that every other judge has to follow. And if you don't do that, your cases will be overturned in the future. Now, no judge wants their cases to be overturned. So the appellate courts or the Supreme Court of the state or the federal appellate courts or the federal Supreme Court make decisions that become law that everybody has to follow. So if you have a criminal case, what attorneys do is cite all the appellate law to get the judge to make decisions about what evidence is admissible and what evidence is not admissible, about which kind of people can talk and what they can talk about and which people can't. Okay? In family court, there's almost no appellate law. Now, why is that? Well, one, if there's no record of the proceedings, how do you appeal the case? Two, how many people have the money to pay for an appeal? Because unlike criminal court, where if you don't have money, it's automatically done by the appellate system. You don't have to pay for it. If you're a criminal, you don't pay for any of your appeals if you don't have money. And even if you do have money, there's a point at which you still don't pay for them. Okay? But if you're in family court, you have to pay to get your case appealed. That usually costs somewhere above $100,000. By the time you hire attorneys, you do all the work you need to do, you pay for the court time, you do all the things. And there's almost nothing to directly appeal because there's no record, because there was no court reporter. And then the case does get to the appellate level. They don't like family law cases because they believe the same thing everybody else does, is they're just a crock of crap. There's just one person who's mad that they didn't get what they wanted, so they don't like getting those cases. So what happens is family law judges, even when we pass laws, pretty much don't have any authority to make them follow the law because there's no appellate decision that will overturn their rulings and make them look bad. So yeah.
It seems that the more power they get, no I'm using that word because I lived through that part. But I won't go there now, but I'm just saying, when there's no accountability and you say there's no laws that they must follow, there's sometimes great temptations.
Yeah, for those of you who couldn't hear it, what she was saying is the more power people get without any accountability, the more likely there's to be corruption. That was what she was talking about. And I think there's some truth to that because, you know, if you look at, and I'm not saying everybody who does child custody evaluations is bad or anything like that, but if you look at how much money they start to make, and the longer a case goes on, the more money they make. And one of the things that Saunders found is that the more contentious the case, and the more you get therapists and psychologists and other people involved, the more that case is going to perpetuate being contentious, and it becomes a vicious cycle. And at some point, there are opportunities for some corruption in there, with people who sort of take a certain position, or people who, you know, get too caught up in the money of what it's about. You know, and so there is room for corruption, yes.
I think there's also a problem that some judges don't believe, they don't like the law. So even when the laws are on the books, they don't follow it. So they listen to the evidence and decide according to their philosophical beliefs and not what the evidence is. And as you said, there's no way to point that out if there's no court reporter present. Also, an appeal takes 2 to 5 years. So during that time, the child is in an environment that's not necessarily the best for them.
Could everybody hear that? Do you need me to repeat it? She was talking about the process takes so long, and just what I was talking about with no accountability and with no court report, and the judges don't want to or don't have to follow the law because there's no accountability. One of the things that's going on right now, for those of you who may not know this, is that over in Berkeley, and Kathleen may talk about that when she comes up here, there's a new family law appellate court project that has been put together by Berkeley law professors, 2 Berkeley Law, third-year Berkeley Law students, and they are doing family law cases, taking them to the appellate courts, and they are going to get decisions on these things. They're going to force family court judges to follow appellate law. They've just gotten started. They work pro bono, so you don't have to go in there with money. If you have a case where there's been a decision and you believe the decision included things that are in violation of the law, or should be in violation of the law, you contact them and they review the cases. I mean, obviously they can't take every case, but they review the cases, and what they hope is that they can get enough cases that look at enough different areas that then even if they can't take your specific case, they'll take a case like yours, take it to the appellate courts, get a decision, and then that will go back, and then the family law courts will have to follow the law. Now, the appellate courts, as I told you, haven't ever really liked family law cases, so they wouldn't hear a lot of them, even if you had the money to get there. Well, how are they going to say that a bunch of law professors from Berkeley are quacks? They're not going to be able to do that. So they are going to hear their cases. They've already won 1 case. All right? They are going to hear their cases because they're a legitimate group of people who have a lot of esteem, have a lot of support and backing. And over the next several years, we are going to get some appellate law in family court here in California that is going to then force family law judges to follow the law just like criminal court judges have to. And if they don't do it, the cases will get turned over on appeal. And if you're a judge, the last thing you want is a case that you worked on to get turned over on appeal. Because everybody knows it. Okay? Again, that Jodi Arias trial, if you were watching, the judge is bending over backwards to allow everything in because it's a death penalty case, and she doesn't want anything to get turned over that she made a decision that excluded anything that would have made a difference. So she's pretty much allowing everything in. Yes? I can't hear you.
Oh, sorry. I was going to follow up with a comment about no accountability because also the problem you don't have the transcripts. If you want to file a complaint with Commission on Judicial Performance for the judge's behavior, they won't even look at your complaint if you don't have a transcript. Well, if you don't have a court reporter in the courtroom anyways, then they refuse to even ever look at your complaint. And then, like in my case, I had to go out and pay almost $1,000 for transcripts and mail them to them before they would finally even look at it. And this is the governing body for judges.
Right, the point she's making, for those of you who might not have been able to hear, is that it's sort of a catch-22. If you have no court reporter, then you have no transcript, then you have nothing to back up what you're saying, and then you can't take it, to the appeals court, and then you can't get the judges to follow things, and it becomes like this vicious cycle of ineffectiveness. That if you did this in the criminal courts, this would be a travesty if this was occurring in the criminal courts, but nobody wants to look at what's happening in the family courts, and people don't know this until they get in it. It's like any of you who have dealt with the family courts, it's like somebody had told you ahead of time that the family court system doesn't have court reporters, there's no transcript of the proceedings, that the judges just do kind of whatever they want to do, that presenting evidence is not particularly effective, that calling witnesses may not happen. You go, huh? Sort of like my dog does. Cocking your little head and going, huh? You had something back there.
If a child makes a statement in family court that she's been sexually abused, does that mean she's totally cut off from protection by the criminal court system? Why, I'm not understanding why there isn't any criminal investigation.
Well, the question is, if a child in family court says they were sexually abused, why doesn't that trigger a criminal investigation? What it usually triggers, and anybody can correct me if you think I'm wrong, what it usually triggers in family court is a CPS assessment. So CPS, excuse me?
What if the protective parent and the child on their own went to the police or to try to get...
Well, let me answer that question, okay, as best I can without us turning this into a turf war here, because I can see all the protective parents getting all riled up. I can tell who you are. I'm not a lie detector, but I'm figuring out who you are out there. Part of what happens in family court is, okay, people do go to the police. And as soon as the police find out you're in family court, their attitude changes. So I've even read in the police reports, this case is currently being assessed in family court, so we're turning it over to CPS and family court to make a determination. So CPS is usually who comes in. And I don't know what the percentages are of unfounded cases that CPS looks at for child sexual abuse. But okay, you work for CPS. All right, does anybody here work for CPS? You probably don't want to raise your hand if you do. That just occurred to me as I said it. I don't think everybody who works for CPS is awful. I think most of the people who are on the front lines of CPS are very inexperienced. They've just got, their ink's not even dry on some of their diplomas. And some of them have been there a long time. But I think what happens is, again, if CPS thinks that they somehow, because you work for CPS, have the ability to tell whether someone's lying or telling the truth without collecting evidence, then they're no different than me doing it. Okay? So what happens is, because it's a family court case, the criminal system shuffles it back to family court. And then family court will get someone from CPS who has no more authority or ability to collect evidence or do an investigation than I do to make an assessment of whether the case is founded or not. Now, what's their bias? Their bias is it's a family court case, so it's probably unfounded. Almost all of the cases that are unfounded. So then it goes back to family court, and now we have a document that says this person made an allegation, this child made an allegation while they were with this parent, and CPS says it's unfounded, so now we're going to flip into turning it back against the person who made the allegation, the parent and the child who made the allegation, that they're lying. See, unfounded doesn't mean lying. It means we don't know. Inconclusive means we don't know. Okay, but the family court looks at that as somebody lied. So even if, yes, it seems like logically, just send them down to the sheriff and make a report. Okay? Or if they disclose to me, I'm a mandated reporter. I make a report. I don't usually call CPS. I send my reports to the sheriff's department because I tend to get a better response there, and they tend not to piss me off so much when I talk to them. Okay? When I talk to the people on the phone at CPS when I make a mandatory report, they never cease to piss me off. Okay? So I don't call them anymore. I call the sheriff instead. Okay?
Yeah.
But then what happens is, if, once they start looking at it, if they find out it's a family law case, they defer it back there. So it becomes this vicious cycle of inefficiency.
Right.
Meanwhile, we have a child over here who is harmed, and the longer we go without supporting that child, the less validated that child feels. And the more that child is going to start to back off and say, start to believe maybe it didn't happen because all these people are saying it didn't.
Yeah.
So then we have a child who, then we get all of the ramifications of that. Yeah.
I thought it would be helpful if I have been involved with the child abuse system for 20 years, so mostly everything is from the School of Hard Knocks, but child abuse is against the law. It is litigated in criminal court under penal codes.
Yes.
But child abuse by a parent is different. If there are custody issues, it is litigated in divorce court.
Right, that's exactly what I've been saying.
Under family law code.
Right.
If there are no custody issues, child abuse by a parent is litigated in dependency court,
Correct.
not criminal court, under welfare code, not criminal code. So like a lot of these questions is, why can't we go to the police, and what about the law, and that kind of thing? What about law enforcement? It's because child abuse by a parent is different.
Exactly, and what she's saying is child abuse by a parent is treated differently, even by the law, the codes that govern it, if it's by a family member.
In dependency court,
Dependency court's better than family court, by the way. She's talking
it
about
trumps,
dependency court.
it trumps family court.
And dependency court actually operates like a real court.
However, let me insert this because this is fact. The one and only law mandated by legislation is reunification. Once a parent is found guilty of abusing their child, the one and only goal is reunifying the abusive parent with the child they abused.
Right, if it's
I
in
recently
dependency court.
went to a foster care meeting, just mostly for information,
Right,
and here's what the leader said. She was the leader of like Child Protective Services. She said that the foster care family that were there, she said, when we give you a child, it's going to be a child that's been abused. And the thing is, she said that the judge will have a court order to reunify that child that you are fostering to the parent that abused that child.
that's correct.
And she said, see that door? If you do not follow that court order, you can leave, exit the door right now, because the child you're fostering will be reunified by court order
Right.
with the parent that abused. If you can't reunify them, then you can leave now.
Right, and
Just to tell you the
the
system.
point that she's making, and I'll paraphrase, is that how cases are handled, it sort of gets shuffled to different courts, and particularly if it's a parent who's accused of sexual abuse, it's treated differently than if it's a stranger or an acquaintance or a teacher or a baseball coach or anybody else except a parent. When a parent's accused of sexual abuse, it gets thrown many times into a different system. So it's thrown into the dependency courts or it's thrown into family courts. Now, I've done some work with the dependency court system, and one of the things with dependency court, and yes, you're right, their goal is reunification. It's always reunification. However, one of the things with dependency courts is at least they listen to the evidence. Things are presented in dependency court where witnesses are called and evidence is presented. So dependency courts are better at assessment of child abuse than family courts are. Family courts are the worst because you have all the people doing it who have no ability to make that decision. And certainly criminal courts have the highest standard in terms of looking at the evidence, presenting the evidence, witnesses coming forward, and that sort of thing. The more you trickle down in the system, the more the system really does trickle. So that if you're in a dependency court situation and whether you're a foster parent or whether you're a protective parent or whether you're the parent who committed the abuse, this child is again being put in a position of being told, well, we're sorry that happened to you, and that, the person will be kind of punished in a little bit, but you got to get over it. Because what we're going to do is we're going to reunify you with that parent. And the way we're going to do that is we're going to assign you to all these really good therapists. That 80% of us think we're really good. These really good therapists who are going to help you reunify with the person who hurt you. And too bad if you don't want to do that, because we're ordering you to do that. And if the parent you live with doesn't cooperate with that, we'll take custody away from that parent and either give you to the parent who abused you or put you in foster care. So the system sort of starts bending in on itself. Yes?
So are you saying that reunification is inevitable? There's no other options?
The question is, am I saying that reunification is inevitable, there's no other options? If you're in criminal court, there's no reunification. The person gets put in prison or gets sentenced or done whatever, and there's a restraining order, and there's zero expectation that the person who's the victim is going to have any more contact with the person who perpetrated the crime. As a matter of fact, part of if they go to prison once they get out, or if they go to jail once they get out, part of their probation or part of their parole is they can have no contact with the victim. That's if you go to criminal court. Now, if you go to family court or where you're not believed, or juvenile or dependency court, then basically what they always want to do is reunify. Their goal is reunification. So, and I'm not saying it happens in every case, but that is their goal, is they want to reunify families. So if the person was put in prison, I know people who have come out of prison and then gone to family court to try to get custody of the child that they abused. Once they flip to family court, then we get into this craziness again. It's like, okay, the person was put in prison for sexually abusing this child. They did 7 years, now they're out, now they want to see the child, and we go to family court, and if the kid says, well, I don't want anything to do with that person, or the mother of the child, because usually the perpetrators are male, so I'm being sexist here, there are female perpetrators of sexual abuse, but she says, the mom says, I don't want my ex-husband to have any contact with the child. They say that in family court, and family court says, well, why would you want to be alienating the child from this father who has done his time, who's done all the programs, who's done the rehabilitation, who is in counseling, and his counselor says he's good to go. Okay? The family court will then look at that and go, well, why are you putting the brakes on this process? So again, if it flips over to the family court, you're back in the same situation, even if it was in the criminal court. Yes?
What's your experience with, or what have you seen as far as kids who are starting to get older, who are in custody of their perpetrator, and they're trying to get out on their own?
The question is, what have I seen with kids who are getting older? We see everything in the book with kids who are getting older, because many of them are so damaged by the system that was supposed to help them that they don't know up from down. A lot of kids, what we see is as they get older, some of the kids, what we see is that they, once they're 14 or 15, they say, I don't want to go on visitations with that person anymore. And even though the law says that until you're 18, the family court can determine what you do, most of the time